Hi, everyone. This is David Stous. I'm a partner at Husch Blackwell and co-leader of Husch's data privacy and cybersecurity practice group. Joining me here today for our webinar is the usual crew. We've got Bob Bauman and we've got Ephraim Hintz. For those of you who have joined us for our prior webinars on the CCPA, welcome back. For those of you who are joining us for the first time, welcome. Thanks for finding us. We're excited to give our presentation here today on the Attorney General's proposed CCPA regulations. Before I begin, those of you who attend webinars on a regular basis know there's always some preliminary housekeeping items. The one I always tend to point out is questions. Feel free to ask as many questions as you want. We have a dense presentation today. There's a lot going on here for us to unpack. We'll do our best to get to your questions, but the likelihood is we'll probably be answering them with follow-up answers. For those of you who have received emails from me on Saturday nights or Sunday mornings answering questions from webinars, you know we're pretty adamant about trying to get responses to your questions. There's a resource list icon at the bottom of your screen. Feel free to take a look at that. The presentation today is not eligible for CLE credit. Given that we put this on 3 working days after the regulations were issued, it's impossible to get CLE credit lined up that quickly. And for those of you interested in a recording afterwards, a recording will be available. A link will be sent to you via email, and also the recordings go up on our website. There's a landing page that we have for all of our CCPA resources, huschblackwell.com/CCPA. With that, let me dive into the substance of today's webinar. For those of you who have attended prior webinars that we've done, I like to start with a slide that gives you the roadmap for what we're going to do here. Not a lot of mystery involved with this presentation. First, I'll take you through just an overview of what we see going on here, giving you some dates and some context. And then we'll move into the analysis of the articles. For those of you who are looking and saying, number 2, there's 7 articles, not 6 articles, that's absolutely true. But the 7th article is a severability clause, which we will not be getting into because it's a severability clause. So we'll take you through articles 1 through 6. Bob, myself, and Ephraim will jump in through those. And then we'll try to give you some takeaways. Listen, in general terms, I think as you all know, this stuff is pretty dense right now. We're going to try to get you through it and try to give you some takeaways. And I'm sure over the next few months, we're all going to be diving into all this information a lot further. Somebody asked me the other day about, what's my takeaway from the regulations so far, and I said, the CCPA, we've all been talking to our clients about it, working through compliance measures for over a year. And trying to figure out and unpack everything that's in here. The regulations are equally dense, and it's going to take some time to unpack all this stuff. So with that, let me sort of take you then into the overview slide and give you some numbers. So again, 7 articles that are part of the regulations. As part of the process, remember these are proposed regulations, these are not the final regulations. So what comes next is they've already announced, the AG's office has already announced that they're going to be hosting public forums December 2nd, 3rd, 4th, and 5th, obviously in California. And there's also a written comment period, and that will cut off on December 6th. Obviously, this is all running together with respect to how they're going to solicit comments as to these proposed regulations. After the comment period, obviously the AG's office will be issuing what it considers to be its final regulations at a to-be-determined date. The process then, and this comes out of the AG's office fact sheet, which I will give you a link to in a moment, they will provide 15 days for additional comments as to those final regulations. And then once it's done, in their mind, the OAL has 30 working days to review the final regulations, and then they become effective. Again, this is in the information provided by the Attorney General's office as to how they anticipate this going out. The answer that, or the question that you're probably thinking is, when's the time frame? I don't know the time frame right now. Obviously, December 6th is the cutoff for written comments. By all accounts, the guidance that, or the public statements that the AG's office is making on this right now is they are hot to trot on getting this across the finish line. I think that's indicative by the fact that they released these regulations last week. They released them before the governor had even signed the amendments to the CCPA. And I think that took a number of us by surprise by how quickly the AG's office was getting these out there, but they want to get them done. And I think that's indicative of sort of the time frame. So then, the articles, we talked about these before. We're going to dig into each of these, but these are the titles that are given by the AG's office to all the articles that they promulgated regulations on. We'll take these one at a time. Again, we're not going to touch on severability for obvious reasons, but we'll take you through the other 6. Okay, so before we take you through the other 6, I think it's worth talking a little bit about what did not happen. And, this is sort of the questions that we've gotten over the last few days and questions that clients have been asking us over the last few months about, are they going to issue regs on this? Are they going to issue regs on that? So I wanted to at least talk about what they haven't done before we get into everything that they have done. First, there's no changes to the definition of business. This was not one of the topics upon which the AG's office was supposed to be promulgating regulations, but a number of clients have asked us about that over the past few months about, hey, is there going to be any clarification on business and some of the caveats in there about, records and all that type of stuff, or, is the $25 million applicable nationwide or locally? There's nothing in the regs that clarify that. Second, a number of clients have asked, okay, well, what does it mean to be doing business in California? There's nothing in the regs that talk about that as well. We've had that question come up a lot. Two of the topics that the AG's office said that they could promulgate regulations on, but they did not, were modifications to the definition of personal information and unique identifiers. I think that makes sense. I think those are provisions that down the line, as technology develops, as industry develops, there may be additional personal identifiers or unique identifiers you're going to need to add, but they did nothing now. The exceptions, lots of discussion about the exceptions, whether or not they were touched. They were not. The GLBA and HIPAA exceptions and all those of the like were not touched with these regulations, so they remain intact. There was no further guidance provided. There are certain provisions that obviously are going to be relevant to the exceptions, and we'll talk about those, but those are generally applicable. There's nothing, to provide context as to what, all the questions surrounding GLBA and how that's applied in HIPAA, et cetera. And as Bob will talk about in a few seconds here, there's a lot of guidance that they provided on notices, but there's no form notices. There was a discussion about whether or not the AG's office would actually promulgate, a foreign privacy policy or something that provides some sort of guidance. They've given guidance on this issue, but there's no form at the end of the regulations. Before we move on then to Bob's, I just want to give you this page. My hope is that when you download this slide deck, that these will all be linkable. They're supposed to be linkable. So you'll have links to the proposed regulations and the initial statement of reasons. And I think it's worth just sort of talking about what we're trying to unpack here today. The proposed regs are 24 pages long, single-spaced. Lots of regurgitation in there from the CCPA, but to sort of give you a context, the CCPA, when you print at least Senate Bill 1121 pre-amendment, is about 16 pages, and the proposed regs are 24 pages, single space. So it kind of gives you an order of magnitude there. There's also an initial statement of reasons that hopefully is hyperlinked there, and that is about 47 pages long. There's a lot of regurgitation with respect to the regulations, but there is some context provided in there. There's also the CCPA fact sheet. I think that's worth taking a look at. There's some limited discussion in there about GDPR and CCPA and just how the AG's office it's like 3 or 4 bullet points, right? But for those of you thinking about, privacy policies and your Article 28 agreements within the context of GDPR, that's something that you want to take a look at. And obviously the press release announcing the proposed regulations. And last, we always talk about this at the end, but I thought it was worth noting at the beginning. we've got this privacy blog that I think a lot of you are already subscribed to. For those of you who are not, if the question is, well, how do I stay up to date? How do I keep on diving into these regs to understand how they apply? Subscribe to our blog. We're going to continue to dive into these regulations, talk about them more, especially when the final regulations come out as well. With that, let me go ahead and turn it over to Bob, who's going to talk to you about Article 1.
Good day, everyone. This is Bob Bowman. I'm a partner here at Husch Blackwell. I'll kind of go through the first two articles here with you. We'll get to the general provisions. Essentially, there was a general statement that violations of the regulations will be considered violations of the statute under the law. I think that's just kind of a general notice to everyone. There's also a number of definitions that were provided, and I kind of included a couple notable definitions that stood out to me. The others were kind of self-explanatory or just related to the regs. The first one is affirmative authorization. That's a question I get often when I'm drafting terms of use and privacy policies, is how do we document or what should we do in order to evidence, authorization? Do I need a click-through? Do I need a consent? Does someone have to fill out a form? So this provides a little bit of guidance here. Generally, it means an action that demonstrates the intentional decision by the consumer to opt into the sale of personal information. Now, mind you, there's two designations for children under 13. That probably encompasses a very small percentage of you all who are, targeting websites or services to children under 13. But essentially, that requires the affirmative consent of a parent or guardian and kind of an alignment with CCPA. And then for all consumers over 13, it is a two-step process. So I always like to consider this a consent plus, where you get an online consent, you follow it up with an email or some or separate confirmation by the end user. And then household, that wasn't defined very well in the statute. Essentially, I think it's a pretty straightforward definition and one that was kind of intuitive, but it just means a person or a group of people occupying a single dwelling. So again, not too much surprising in the definitions that stood out. Now we're going to kind of get to your the first date with your consumers, as I like to say. These notices from a compliance perspective seem pretty tedious and burdensome at some points, but really this is what the regulators and the law enforcers of the law are going to look at first. And so any shortcomings and failures in this, we'll start on to the next step. So, you put on a good face, and that's half the battle. So some of the general points of emphasis from the AG's office was that these notices need to use plain, straightforward language with no technical or legal jargon. Use a format that draws consumers' attention to the notice and makes the notice readable. And including on smaller screens. So for those of you who offer mobile applications or mobile versions of your website, get with your designers to make sure that those terms of use or these privacy policies are readable on a mobile device. Available in language in which the business operates in its ordinary course. So I would say most of you probably will have an English language privacy policy. To the extent you operate in other languages, you'll need to make translations of that document available to your consumers. And then be accessible to consumers with disabilities. And so this, it's notable that they put this in writing and require it. I think it's been an understanding that websites need to be ADA accessible, and there a little while back, and there was a flurry of plaintiffs' lawyers out there targeting larger companies regarding the ADA accessibility requirements for their websites. I haven't heard much of it lately, question here or there. But this is something as you're revamping your websites and looking to comply, just to do a little research, check with your IT guys, check with your web developers, just are these based on the compliance. The ADA website has a whole section on website compliance. And then there's an organization called w3.org that also provides some guidance more on an international level of having accessible websites and those that are usable and beneficial to users with disabilities. So the first notice that we are going to discuss here is the required notice at collection. So the CCPA requires that businesses who are subject to the law notify customers of your collection and use of personal information at the time of collection. And so you must disclose the categories of personal information and the purpose for collecting the personal information at the time of collection. So one thing of note, and that the AG's office and the regs emphasized, was that if you do not have a notice at collection, you will be in violation of the CCPA, and you may not collect or use the personal information of California residents. And so, they're really emphasizing this notice aspect of the law. Some of the other principles is you can only collect and use the personal information as you disclose it. So that's kind of the old adage, I think, under the old sort of FTC governance of privacy laws, is the notice requirements, and that you're only processing and using information on how you disclose that to your consumers, so there's not a big surprise there. And then you have to update anytime you change how you use or collect or what types of data you collected, you need to update your notice and consents. So just to kind of an overview of the required content for the notice at collection. Again, a list of the categories of personal information about consumers to be collected. For each category of personal information, the business or commercial purposes for which it will be used. And then if the business sells personal information, you need a link titled "Do Not Sell My Information" or "Do Not Sell My Info." Or if you're providing an offline notice, like if you're collecting information at a point of sale, you'll need to provide an offline notice which provides the web address to the web page for the privacy policy. So what else will be required if you're collecting data online is a directed hyperlink to the section of the business's privacy policies that contains information required above. Will meet the notice requirement. So if you have a user registration form, a link at the bottom that's a directed link. So a general hyperlink to the privacy policy doesn't comply with this requirement. It needs to take the user specifically to the section that provides the categories of personal information and then the purpose for which it will be used. So there are exceptions to the requirement notice at collection. So for businesses that do not collect information directly from consumers, you do not need to provide a notice at collection to the consumer because I guess that's kind of circular because you're not collecting any information. However, you can't use this exception to get rid of your obligations to consumers that you are using information. So if you obtain personal information from others, such as data brokers or other sources, maybe affiliates, then you either have to obtain the consent from the data subject to use their data, or you need a statement from the source of the personal information that sufficient notice at collection was obtained or was provided, and then a copy of the notice. So it's really a way for the AG to try and prevent people from working around this notice at collection, and goes along with the theme of the CCPA, is that businesses should be answerable to the consumers for how they use personal information. So the other notice, another notice, is the notice of right to opt out of sale of personal information. So the purpose of this notice is to inform customers of their right to direct a business that sells or may in the future sell their personal information to stop selling their personal information and to refrain from doing so in the future. So for online businesses, a do not sell my info or do not sell my personal information link on your homepage is what's required here. In addition, and you'll notice some notes in the regs about an opt-out button on your web page. You'll specifically note when you read that section that it says that may be used in addition to and not in lieu of the link on your homepage. So offline businesses need to still provide this notice through another method. That could be printing the notice on paper forms where you collect information, providing a paper version of the notice, and posting signage with the website and link containing the notice. So as a reminder, under the CCPA, sell does not mean sell. So sell means sharing personal information with a third party for monetary or other valuable consideration. So, please keep in mind that this notice of right to opt out to sale of personal information does not just cover, selling a list of your customer and their data to another party for money. It means any exchange with a party for some sort of valuable consideration. So that encompasses a wide swath of activities, at least in e-marketing applications, and kind of the way that data has been treated and shared, in the ordinary course of business to date. So the regs kind of imply that there should be a web page that is the result of clicking on the link of do not sell my info or the opt-out button. And that web page must provide the following: a description of the consumer's right to opt out of the sale, the web form by which the consumer can submit their request, or an offline method by which the consumer can submit their request to opt out, any other ways to submit their request, and any additional proof required if you're using or the consumer is using an authorized agent to exercise this opt-out, and a link to the URL to the business privacy policy. So the way, at least the initial impression on my end, is that this needs to be a separate web form, a separate page than what is just your privacy policy. So the exemptions, a business that does not sell and will not sell personal information collected during the time period does not have to provide this notice. And for those businesses, you must state that fact in your privacy policy. Because the definition of sell is fairly broad, well, I guess we're going to down to the next one because that'll kind of explain my comment there. So if you collect personal information from a consumer while you don't have the notice of the right to opt out, while you don't have that posted on your website, essentially that information from the consumer, and the consumer is deemed not to have validly submitted a request, or will be deemed to have validity submitted a request to opt out. So essentially, that if you don't have this notice up and the required links and the web page and everything else, any information that you collect, the default will be that the user has not has opted out of your ability to sell that information. So that kind of goes to, as you're working through compliance, and maybe you don't sell it now, but you might want to in the future, we would suggest including this because to the extent that you don't include it initially, you'll have to go back and obtain consent from those individual users after the fact because they will be deemed to have opted out of the sale of their information. There's also a notice of financial incentive. So the purpose of this notice is to explain to the consumer each financial incentive or price or service difference a business may offer in exchange for the retention or sale of a customer's personal information so that the consumer may make an informed decision about whether to participate. So for those of you who were on the last webinar, one of the revisions to the law was that businesses can charge or can provide different levels of service and or charge fees for use of services, differences based on the value of the information to that business. So what that means, so for free services like Gmail or Facebook, those that don't charge any money for their services, they make money off of the use of the data. They now, if somebody opts out of everything, can potentially charge for that service, but the charge must be related to the value of the data, the value of that consumer's data. Now, I've kind of, preparing these slides, there's a lot of information here, so I'll kind of hit the highlights here. But I wanted to have you all to have it just in case you use this as a reference moving forward. So online, if a business offers the financial incentive or price difference, the notice may be given by providing a link to this section of a business's privacy policy. Again, they seem to be stating a direct link to the section in which you provide this information, not just a general link to the privacy policy. And that notice must contain a succinct summary of the financial incentive or price difference offered. So if one's a free service and you're charging a fee, you just need to provide that kind of succinctly. What is the deal? So what information is collected for the incentive? How to opt into the financial incentive or price or service difference? Notification of the right to withdraw from an incentive program, and an explanation of why the financial incentive or price difference is permitted under the CCPA. So what this also requires is a good faith estimate of the value of the consumer's data and a description of the method the business used to calculate the value of the consumer's data. This is kind of an interesting inclusion in the regulation because there was something similar to this that was presented in an amendment that didn't make it through, which was that the business must provide a good faith estimate of the value of a consumer's data. So this seems kind of to be that if you're going to exercise this ability to offer a financial incentive or have a different price or somehow compensate people for the use of their data, that now you need to provide an estimate of what that data is and the method by which you use to calculate that data. Now kind of to the overarching privacy policy. Again, most of you are likely familiar that the purpose of a privacy policy is to provide a comprehensive description of a business's online and offline practices regarding the collection, use, disclosure, and sale of personal information and of the rights of consumers regarding their personal information. So this must be posted online through a conspicuous link. The link must use the word privacy on your website. For businesses that do not operate a website, they should make the privacy policy conspicuously available to consumers. That will be a discussion in the future of what conspicuously available means. And an interesting addition that's probably a little bit of a variation from standard practice today is that the AG's office right now is requiring that there should be that the privacy policy should be available in a printable format. So probably likely that you could download a PDF or get a PDF version that's easily printable. Content of the privacy policy. So the privacy policy should include the following information: a listing of the rights provided under the CCPA, and information regarding exercising those rights, and information regarding the personal information collected, disclosed, or sold. The privacy policy needs to include verifiable request instructions. I think David will get into that a little bit in more detail a little bit later. Need to provide notices about collection of personal data. So this is kind of a regurgitation of the notice at the time of collection, except for there's a few notable differences. You need to provide categories of consumers' personal information the business has collected in the last 12 months. And then for each category of personal information collected, you need to provide sources from which that PI was collected, the business or commercial purposes, and the categories of third parties with whom the business shares personal information. So again, this is a little more detailed than what's required in the initial notice at collection. You need to disclose sale of personal information. So state whether or not the business has disclosed or sold any personal information to third parties for a business or commercial purposes in the preceding 12 months. List the categories of personal information, if any, that is disclosed or sold to third parties in the preceding 12 months. So you'll notice on this page, the use of preceding 12 months is used 3 times. The way that we're treating this is that now the CCPA essentially requires companies subject to the CCPA to perform annual review and or updates of their policies. So this is becoming an ongoing regulatory compliance burden for companies under the CCPA. The last information is whether you sell any personal information of anyone under 16. So these kind of follow the requirements of the law well. So moving on, the next right is the right to request deletion of personal information. Again, explain to the consumer that they have this right, provide instructions for submitting a verifiable request, and then you have to describe the process with which you will use to verify that the request is valid, and then executing the right to delete their information. Again, so this goes to the broader aspect of making sure that your compliance strategy is defined up front, because part of your operations and your administrative procedures need to be presented to the consumers in this privacy policy. So again, the right to opt out of the sale of personal information, we kind of touched on that earlier. It also needs to be included in the privacy policy. So explain that the consumer has a right to opt out, and then contents of the notice to right to opt out or a link to it. The right to non-discrimination for the exercise of the consumer privacy rights. So this section, generally the CCPA prevents you from discriminating against consumers who exercise their rights of privacy. The financial incentives aspect of the CCPA is one of the exceptions to that right to discrimination. So this is where you provide, to the extent that you are either providing a financial incentive to use a person's personal information, this is where you would include it. And then finally, information regarding designating an agent under the CCPA to act on your behalf, and then identifying a responsible contact at your organization who will receive requests for information or provide explanations or be the link between the consumer and the company. That concludes my portion of the webinar. I'll hand it back to David now to to discuss Article 3.
Yeah, thanks, Bob. And I think probably it's also, in light of what Bob just went through, obviously it's dense. I mean, listen, you can tell that just by the amount of information that's on the slides themselves, and hopefully they're a useful resource for you to have too much information rather than too little in this context. But to sort of step back and to just have a feeling for what I think has happened here through the CCPA and now the regulations, and Bob and I have talked about this a lot over the last few days as we've tried to build this out, this presentation out. You've gone from a statute in California, CalAPA, the Online Privacy Protection Act, which essentially says, it's one page and it says talk about these 6 things, right? And you've got the Shine the Light law, which has some more context there. And there's a few more things obviously floating around that we put into privacy policies. But now you've gone into this incredibly dense analysis of privacy policies, where they have to include specific requirements behind that go on and on for page after page after page. And I think what we're really, we were trying to come up with a frame of reference here, right? And it's also worth noting as well. I mean, if you get it wrong, that's a violation of the regulations. And as Bob said at the beginning, a violation of the regulation is a violation of the CCPA. So there's a consequence if you get it wrong in the eyes of the Attorney General's office. I would also mention as well in the opt-out provision, if you're not providing the ability to opt out, then it's presumptively that everyone is opted out, right? And you can't be making transfers of information to third parties, how that works. But as we talked about it and trying to come up with almost an analogy, right, for how we would relay this, and I don't know if it's an apt analogy, but in the context of say, if you're a public company and you're making annual disclosures through a Form 10K, and the type of time and attention that you spend making those disclosures to consumers about the things that are required in your annual 10K, I think is the same level of detail that the AG's office is envisioning that you're going to put into your online privacy notice and these other notices as well, that will tell, again, consumers about the types of information you're collecting and how you're transferring this. So this is, again, this is something that I think on a company by company basis, this is something that is a real monumental shift in the way that these notices are going to have to be developed to be able to be consistent with California, and then presumably when all these other statutes come out as well in the next few months or years, however long it takes for other states to jump in. The next topic then that we wanted to chat about is, it's Article 3. It's the next one in sequence, right? And as the name will tell you, this is the business practices for handling consumer requests. And this is, if you go through the regulations here, they kind of jump around a bit. And so I've tried to pull it together and synthesize the various portions and synthesize them based on the type of request. So what we're going to go through is a request to know, request to delete, and request to opt out. There are a few items that I'm not going to get into that are in these regs. There's a request on behalf of households. There's also opting in after you've opted out. Just be aware that they're there, but I mean, honestly, we'll lose you if we get too far in the weeds. So request to know then is our first one we wanted to chat about, and Bob talked a little bit about this during his slides as well. The regulations, consistent with the CCPA itself and the modifications that happened, they talk about how are you going to receive these requests to know, right? And when I say request to know, we're talking about two different things here. We're talking about to know the specific pieces of personal information that the business has on the consumer, and also to talk about the categories of personal information. So specific pieces and categories of PI that are collected, and we'll talk about those a little bit in a second. So in any respect, the regulations provide some clarity on what you must include for this request to know, toll-free telephone number, interactive web form. Bob talked about that. And envision some other methods as well, in-person or mail-in forms, as well as email address. And one thing I should keep in mind as well, right, is, and it's going to be consistent with all of these requirements on how you receive these requests. There is guidance in the statement of reasons, which is one of those long documents that I was referring to at the beginning of the presentation, that they basically say, you can't use obscure methods, right? And you have to keep in mind the type of methods that will actually be accessible to the consumers themselves. And so that's an underlying concept. They have things about what you must do, but it also has to be done in light of how you interact with consumers. And if you interact with consumers a specific way, then you've got to incorporate that into your requests. So I just talked about this, right, about these two different types of requests, the specific pieces of PI and the categories of PI. So the next thing then is, when you're responding, we went through how you're going to receive the requests. When you're responding to them, there's this concept, and we'll talk a lot about it in the next section, Article 4, about verifying the identity. It's a very big issue with the CCPA. It's how you're going to verify someone is who they say they are. And this makes sense here, how I think the AG's office has conceptualized this. So if the request is turn over to me all the specific pieces of PI that you have on me, which is obviously a very sensitive issue, they have one set of requirements. And if you cannot verify the person, that's a predicate here. If you can't verify the person, then you're not allowed to turn over pieces of personal information. That makes complete sense, right? But you got to notify the consumer that you can't verify their identity. And then you've got to then treat that request and analyze whether or not you can treat that request as one of which they're asking for the categories of PI. And so then we go down to the next portion there, the categories of PI. If you can't verify the identity, you may deny the request. Again, you have this notification obligation to the consumer, and you see this running throughout and responding to these requests. And it's something that was not in the CCPA, but something that a lot of clients have asked about in the last year is, what do I do? Do I have to respond? All those types of things. The regs provide some guidance on that, right? So in any respect, if you get a request on the categories of PI that have been collected about the individual consumer, as opposed to specific pieces of PI being turned over, then you may deny the request if you can't verify the identity. You have to notify, and then you also have to direct the consumer to the disclosures in your privacy policy. So a lot of moving pieces here. Then taking that first category again, the request for specific pieces of personal information, this is new. Pay attention to this, okay? This fundamentally changes one of the aspects of the CCPA. You've got this concept of a risk analysis. So again, this is somebody coming to you and saying to the business, I want you to turn over the specific pieces of personal information that you have on me, right? And people like myself and Bob and Ephraim and everybody else that you've listened to on the CCPA have said this is a hacker's paradise, right? Impersonate somebody using information they've gathered from other sources and have businesses turn over really this type of information as the core PI that is covered by data breach notification statutes, for example, right? So if you look at the second bullet point here, the regs actually specifically forbid you from turning over certain pieces of personal information. Socials, driver's license numbers, health insurance, medical information. Where does that come from? It comes from the breach notification statute. That's where it comes from, right? So the CCPA tells you have to do it, and the regs say, no, don't do these specific things. This is a good change, but it's also almost a gotcha type thing, right? If you're not embedding this into your compliance methodology. And the shout out the risk analysis as well, right? So that's this sort of layer over top. And basically it says, if you think there's a risk here, of a security risk involved here, an identity theft risk, then you shall not disclose it, right? And unfortunately, they don't provide much more guidance other than that. But point being is, in your policies and your procedures to respond to these things, you're going to have to embed these regs into it. Now, requests for categories of PI, again, going from the specific pieces to the categories, right? This is something to take note of as well. It has to be an individualized response. You can't just refer the person and say, well, look at my privacy policy, right? If you are collecting categories of PI and somebody wants to know what you've actually collected on them, then you've got to identify what you've collected on them, unless the collection is going to be the same for everybody, and then you can, the response will be the same for everybody, I should say, and then you can refer them to your privacy policy. But it's an individualized response even for the categories of personal information. Okay, exemptions. This is a big question we've had over the last few months, right? So say you're an entity subject to the Husch Blackwell Act, right? And you have personal information on the GLBA is exempt from the CCPA. I know I'm getting way too facile about that, but we've done entire webinars on those issues. But the question that we've gotten a lot is, okay, well, say I've got personal information, say it's all covered by the GLBA, do I have to respond to a request? The answer is you do need to respond to a request. It is not enough for you just to stick your head in the sand and say, I'm not subject to the CCPA to the extent of this, right? What you're going to need to do, and this is not just GLBA, but it's any exemption that you're relying upon, right? You're going to have to notify the consumer. You're going to have to explain the basis for which you are denying the request, and you're going to have to respond to the extent that's not covered by the exemption, okay? So some welcome clarity on this one. Frankly, this is the guidance we were providing to people anyway. I felt like this was always good consumer relation purposes, that you should respond. You should try to avoid people going to the AG's office and saying, my request hasn't been responded to, but now it's part of the regulations as well. Means of disclosure, okay, we've gone through this process of receiving and verifying. We'll talk more about verification in a second. How do you disclose? And again, this is request to know, right? This is the guidance, reasonable security measures, great. And this is something really that we're seeing within the construct of the CCPA, a lot of struggle on the InfoSec stuff, right? And it's in the statutory damages provision for data breaches as well. Here they say use reasonable security. You can use a password protected account. It was part of the amendment process as well. You can use your authentication methods that you originally built in as well. So something that you can leverage to get this across the finish line. The time frame, new. So this 10-day period at the top is new in the regulations. What they want you to do is when you receive a request to know, they want you to confirm receipt and provide some information to the consumer. We've got that there, right? And they want you to provide that within 10 days. You can scour the CCPA. You will not find anything about 10 days responding to a request to know, okay? Period. This is new in the regulations. The concept is, if you look at the statement of reasons that the AG's office also published, the concept here is to provide further information to consumers about what their expectations should be, okay? They've also noted that this response can be automated, okay? So you can set it up where there's an automated response that essentially says, thank you for receiving your request for X. This is the process by which we will analyze this. There's also a concept that if you're going to deny the request, that this gives you a time period to just straight up deny the request as well. The 45-day period, that is provided in the CCPA. You have 45 days to respond to the request. It starts on the day that you receive the request. You can take 45 more days, but again, you've got to notify the consumer and explain the reasons why you're taking more time. Deficient requests. And this is, I've got it here in the request to know, but this is applicable across the board to the other requests as well. The concept here is, someone has submitted a request and they haven't used the methodology that you put out in your privacy policy, or there's some sort of technical deficiency with the request. And if you look at the statement of reasons, what they really are getting after on this one here is they don't want businesses using technical reasons to reject requests, okay? They want this to be consumer friendly. They realize there's, the consumers are going to be, across the board doing things that probably don't meet the technical requirements of this. So they set it up that if there's a request that you consider to be deficient, you basically have the option of treating it as if it's not deficient, or providing the consumer with directions on how to fix it, right? You can't just put your head in the sand and say, we're not going to comply with the request. Okay, so let's move from request to know to request to delete. Again, starting from the front end of, what are the methods upon which we should be receiving these requests. And so this is the regulatory guidance on this one. And this is, again, request to delete. And if you look at the statement of reasons that were provided with the regs, what they're telling you is, hey, listen, the CCPA is silent on how these requests should be received. And so, we're providing some guidance on this one. It's the same moving pieces, right? Toll-free telephone number, link/form available online, email, in person, or online or mail-in forms there. So sort of the same, but there's not this. With the prior one, there was a must-use requirement. Here, there's not a must-use requirement. And again, there's this concept that you have to be thinking about how you interact with the consumer and picking methodologies that would really track how it is that you interact with the consumer to receive these requests. There's talk in the statement of reasons that you cannot be picking obscure methods, okay? So online requests to delete. What is the issue here? The issue here is they are concerned about having accidental, as they refer to it in the statement of reasons, requests to delete information, right? I suppose somebody is at home one night and just clicking buttons and all of a sudden you've deleted all their pictures for their entire history or something like that, right? And so they want to do is they want to have, if there's an online request to delete, they want to set up a two-step process to try to avoid accidental deletions. And this is it, right? You've got to submit the request, and it says clearly in the regs. And I always, whenever I see the word clearly, I always think that, nothing's ever clear, right? But they have to clearly submit the request to delete, and then you've got to separately confirm that they want the PI deleted. So you have to set up this process as well for online requests to delete, another aspect here. Responding to the request. Again, this concept we talked about before about if you can't verify the identity, right? And it's a request to delete. You may deny the request. You've got to notify the consumer. Consistent in this. You've got to tell the consumer what you're doing. And this is a really interesting aspect here. So you've got a request and you say, I can't verify the identity of this person requesting me to delete this information. They've created a new requirement in the regulations that you've got to treat that request as a request to opt out of sale. And Bob talked a lot about that in the prior slides. This is new. It's in the regs. It's not in the CCPA. You can go through it. You can't find it, right? The concept there, if you go to the statement of reasons, is this is to provide a benefit to the consumer by preventing further proliferation of their personal information in the marketplace. That's taken from the statement of reasons. But again, another aspect to how you're going to have to drive compliance on these issues. So how do you comply with this? Request to delete here, common sense, number one, right? You delete it. You permanently and completely erase the PI. And this is an interesting aspect. This has come up a number of times, right? On existing systems, with the exception of archived or backup systems, you do not need to go to your backup tapes and delete people's information off of your backup tapes. This is a welcome clarification in the regulations, really something that will provide comfort to people. There's an exception to this one. If you look at the regs, what they tell you is if you go to the backup tapes and you start them running for whatever reason, right, then you've got to actually delete it off the backup system. But you don't have to go on the front end and actually delete the PI off of the backup tapes. It's just if you use those in the future, so you're going to have to log it, right? Two other options then, you got de-identify the PI or aggregate the PI, which is, potentially really good options to go with here. So that way you can keep some of the value of the data at that point in time. Response, again, you've got to tell people what you're doing, right? You got to specify the manner in which the PI was deleted, those three things we just talked about. And then you've got to tell the consumer that the business will maintain a record of the request. So the regs envision that you will, in fact, because, again, the backup tape issue, right, that you will, in fact, maintain a record that so-and-so asked for their information to be deleted. So you're actually retaining a certain amount of information to be able to make sure that you can process the request that the backup tapes happen. Again, just a little caveat here, a wrinkle. Denying the request, again, got to tell the consumer, right? You got to notify them and describe the basis for denial. And if you've attended prior webinars, you've heard me say numerous times, the request to delete has 9 exceptions to it, right? And you're going to want to be looking at those exceptions and figuring out whether or not the exception swallows the rule. And in many respects, it probably will, right? There's going to be exceptions to the exception, but by and large, this is what we see, right? So you got to tell them. It's not just enough to just deny the request. You got to tell them. Again, tell them why you're doing it. And then if you are relying on an exception, you've got to delete the PI to the extent it's not subject to the exception. So you have to do that analysis, right? And then not use that PI for any other purpose other than what you're saying with the exception. So what I think they've tried to do here is they've realized that the exceptions are really broad and may swallow the rule, and they're trying to walk that back a little bit here and to actually make businesses wrestle with these concepts. Okay, time frame. Yes, this is the same slide as before. It's the same time frame. I don't have to get into it again, but the time frame for request to delete and the time frame for request to respond are the same, or request to respond to request to know are the same. Service providers. This is part of Article 3, hard to necessarily envision why they threw this into Article 3. There's a few things like training and record-keeping requirements that's in Article 3, and service providers is in Article 3 as well, right? And what they're trying to do, if you look at the statement of reasons, what they're trying to do is allegedly clarify the way in which service providers are handled. So let me start from this premise, right? Neither the CCPA nor the regulations require service providers to respond to requests, okay? But it may very well be that as you set up your contracts here, and these service providers, again, these are, and one of the ways they clarify this, they're processing information on behalf of the business, right? So a lot of instances when we talk with clients, they have entities that are, you know, essentially the consumer-facing entities. They're the entity that's interacting with the consumer on their behalf, right? In those instances, you'll need to have a contract. To be a service provider, you're going to have a contract, and that contract has to say certain things. And you want to do that. Why do you want to do that? Because you want them to be service providers, not third parties. Because if they're third parties, they're subject to the opt-out provision, and it just becomes a parade of horribles, right? So this concept of going through your third-party management program and getting it right is essential to the CCPA. Cannot emphasize that enough. But they provide some clarity here on the service provider aspect. And what they're saying is, again, they're reiterating, hey, service providers, they don't need to respond to these requests unless they want to, essentially, right? And that is really a contractual aspect of this. If you want your service providers to be responding on your behalf, then you're going to have to deal with that contractually, right? But if they do not respond, again, notice, right? They've got to tell the consumer we're not responding, explain the basis for the denial, i.e. we don't have to, and they're going to have to tell the business, and this is, again, something you cannot find in the CCPA, but it's in the regulations. They have to notify the consumer of the identity of the business and contact information for the business. This, again, it deals with this concept, right, that the consumer may be thinking, you know, I'm dealing with one entity, and they don't know if they're dealing with a different entity behind the scenes, right? And so this is supposed to really address that aspect here. Okay, request to opt out. Again, starting from receipt, right? 2 or more designated methods, one of which has to be this web form. Bob talked a lot about this. I won't get into it. You're gonna have to, if you're you know, subject to the request to opt out, you're gonna have to put stuff up online. It's just the way that it is. Other options that are allowable, you know, the first set there are ones that you've seen before. Again, it all deals with this concept of making sure that it's the way in which you interact with your consumers. The one that's new here and interesting is the last one, user-enabled privacy controls. And then they have some explanation, a browser plugin or privacy setting that communicates a consumer's choice to opt out of the CLPI. If you look at the statement of reasons on this aspect, what they say, quote, is it's intended to support innovation for privacy services that facilitate the exercise of consumer rights. This is essentially a aspirational type of aspect here, as I view it from the AG's guidance, right? But what they want people to be able to do is to be able to understand, you know, if a browser is communicating to opt out. Remember, this goes with cookies, right? And that's where this really becomes an aspect, is cookies and third-party advertising cookies, and how that's going to interact with the way your browser settings, your privacy settings are. And to that point, they have a specific provision on there which says if a business collects PI online, it's required to treat these user-enabled privacy controls as being an opt-out, right? Anyway, some stuff to get into the weeds on. Authorized agent, then. Bob talked about this before. There's this concept embedded in the CCPA about having somebody else make these requests on behalf of someone else. Just understand, I don't want to get too far in the weeds here, you know, there's a lot to get through, but just understand that this is a concept that you have to wrestle with, is that people can be making requests on behalf of other people. Verification. The request to opt out is not subject to a verification. You know, the concept is I don't want my information to be sold, right? So it's not turning over information, it's not deleting information, it's just don't sell my information. So the CCPA does not have a verification provision. The regs do not have a verification provision for these ones, but they recognize that there may be reasons why the business is concerned about it. And if they suspect fraud, then they don't have to comply. But again, you have to notify the individual. You see that consistently. The response timeframes then. This slide is different than the last two slides on response, and it's different in significant ways. There is no time frame in the CCPA for responding to requests to opt out. There's not, with respect to the 15 days on there, right on the top portion there. But the CCPA regs say that you've got to respond as soon as feasibly possible, not later than 15 days. It's new. It's a new requirement. The 90 days is something that needs to be discussed. This is new. It's in the regs, not something you're going to find in the CCPA. Within 90 days, what you've got to do then within this time frame is you've got to notify third parties, again, as opposed to service providers. So third parties to whom you've sold the consumer's PI. So basically, entities that you do not have a contract with, that's not properly buttoned up with a business purpose under the requirements of the CCPA. So if you've made these transfers and it's not a service provider, it's a third party, you've got to go back in the prior 90 days and you've got to notify any of those entities of the consumer's request to opt out, instruct them not to sell the information any further, right? And then you've got to tell the consumer when this has been done. So what is this? And you're looking at this and thinking, this is crazy talk, right? The reason for this is the CCPA, again, it requires in responding to requests, you're not identifying the specific third parties that you've transferred this information to. You're identifying the categories of third parties you transfer this information to. Because of this, and there's a lot of discussion in the statement of reasons, because of this, what the AG's office has done is they've placed the burden on making sure that there's no further selling of the information on the business here and not the consumer, because the consumer does not know who you've transferred it to. They only know the categories of third parties. Again, something that's unique in the regs that you're going to have to build into your compliance. Another thing that came out of nowhere in the regulations is this aspect of if you're collecting 4 million or more consumers' information, right? And again, it's California residents. And if you look at the statement of reasons, what they're essentially saying is, listen, this is basically if your business is collecting 10% or more of information on behalf of 10% or more of California's entire population, right? They literally say that in the statement of reasons. So if you are collecting tons and tons of PI, you're going to have some additional obligations that are going to you have to comply with. And essentially, you're going to have to provide on an annual basis the number of requests that you've received and how long it took you to respond to them. All right, moving on to the verification process then. Verification, I think, is left something to be desired, frankly, in the way they're coming up with verification. And what they emphasize is, if you look at the statement of reasons, what they emphasize is, and this is a quote from the statement of reasons, it's a significant amount of discretion and flexibility to select a workable method, right? Well, I think a lot of businesses really would have liked to have, safe harbors, right? Hey, if I do X, Y, and Z to verify somebody's identity, I know that I'm in good position at that point in time. I want to get it right. I want to comply, right? You're not going to find it. There's no safe harbor here. There's no use a third-party identity verification service and you're good. That's not specifically said. Instead, what they've done is they've come up with basically what I'll refer to as like a totality of the circumstances analysis, okay? And we have these factors here. I'll just kind of work through them here. And I should say as well, one thing I don't have on these slides, but it has to be emphasized, you have to have a documented process. The regulations specifically say that you have to have a documented process. You will need to have a policy in place for how you're going to verify identities, period, by the terms of the regs. And if you don't, it's a violation, just that simple. So anyway, step one in this process that they're envisioning is you're going to, if you can match the information that you have with, what the consumer is providing to you, that makes sense, or you can use a third-party identity verification service, okay? But number two then is, and this will pop up later as well, they want you as part of this process to, if possible, avoid collecting the type of information that's subject to that statute. What is that right there? That is small print, but here it is right here. This is the information security definition, the definition of personal information taken from the information security statute, right? This is the one, they just modified it with AB 1130. Point being is they want you to avoid taking this type of information in to verify, but there's some caveats. Even the example that they give says if you're taking in credit cards, you can ask the person to verify their credit card, the code on the back, as well as a recent purchase, right? Those types of things. but they want you basically the data minimization principle to avoid collecting this type of sensitive information. Then they have number 3 as part of this totality of the circumstances. They have a 6-factor analysis to go through. Type and sensitivity and value of the PI. Well, what is that? Well, they've created this category in the regs that is essentially what I just showed you on the prior slide. That's considered sensitive information, right? And again, many of those things you can't even turn over to people when they get specific pieces, request for specific pieces of personal information. So that's really becoming a subcategory of sensitive personal information. And maybe some of you who really are in the weeds know that that was something that McTaggart's CCPA 2.0 was even coming up with, and that's sort of been foreshadowed with these regulations here. So anyway, you go through these factors here, and you just need to analyze, and this is common sense, I think. If it's really sensitive information, if there's a risk if you turn it over, if there's likelihood of fraud, all those types of things that you got to be driving after it, right? And then it just continues with these other factors here. Whether your protection's in place, and this is what I'll sort of maybe put a finer point to it, because you can read just as well as I can read it to you. To put a finer point, I mean, this is basically how you're going to build out your policy, right? You're going to do a policy in which you're going to go through all of these things and weigh all of this type of information based on what you bring in the door and based on the type of request. Okay. After those 6 factors, then there's these additional portions as well. That's the totality of the circumstances. Again, data minimization is number 4, right? Avoid requesting info that you don't need from the consumer. And then, of course, implement reasonable security measures, and a little bit light in the regulations on what that actually means. They have 2 subsequent categories then. So they have those general requirements, right? And then they have 2 subsequent categories, one of which is password-protected accounts. If you've got a password-protected account, you can use it to authenticate the individual. You've got to, again, you've got to have consideration of those totality circumstances factors I just showed to you, right? And then, you need to re-verify if you're suspecting fraud or malicious activity. But for having password-protected accounts, you're going to have some comfort there that they've envisioned that. For non-account holders, they've created this incredibly complex sort of setup here that makes sense when you read through it and think about it, right? But so this is non-account holders. You don't have a password-protected account. And they've created these categories of, okay, well, what do you need to do when you're trying to verify identity? For requests to know the categories of PI, it's a reasonable degree of certainty, so you're matching 2 data points there. If you're going to turn over specific pieces of PI, then it's a reasonably high degree of certainty, which is basically matching 3 data points, as well as getting a signed declaration under penalty of perjury. That is not a notarized declaration, it's a signed declaration. There's a lot of people pushing for notaries to be part of this. That's not there. And then request to delete, it's basically, you got to have a feel for it based on what you're trying to delete. And there's a couple examples given in the regulations as well. One of which is basically, if you're asking to delete all family photos or something, you would want a reasonably high degree of certainty as opposed to maybe just some innocuous information. Authorized agent, we talked about this before. Let me just skip through this in the interest of time, just to understand, though, that this is, in fact, an aspect of how they want you to go about if you're receiving these requests from somebody else. Okay, turn it over to Ephraim to take you home on Article 5 and 6.
Good afternoon, everyone. My name is Ephraim Hens. I'm an associate here at Husch Blackwell. I'm going to guide you through Articles 5 and 6. So the key requirement businesses need to remember under Article 5, which special rules regarding minors, is the actual knowledge. If a business collects or maintains personal information and has actual knowledge that this information belongs to a minor under 13 years old, they must obtain affirmative consent from the minor's guardian. This is extremely important. The business must go through multiple steps of verifying that this is the actual guardian of the minor, parent or guardian. I've listed a couple examples up here, but if you go into Article 5, you will see numerous examples of how to verify that the person is actually the guardian of the minor. One example is have a consent form to be signed by the guardian under penalty of perjury. Another example is checking the guardian's identity via government-issued identification. And again, on this next slide, you'll see the key takeaway I have for Article 5 is the actual knowledge. If a business collects or maintains personal information and has actual knowledge that the minor is older than 13 but younger than 16, the business must allow the minors to opt into a sale. If you read that again, opt into a sale, so we need an affirmative consent from the minor that he is opting into the business selling his or her personal information. If the minor opts in, the business must inform the minor of the right to opt out at a later date. One exception you'll see at the bottom of this slide is that there's no requirement for a business to provide an opt-out notice to a minor if the business is not selling the minor's personal information, or if the business has already obtained the minor's guardian's affirmative consent. Now let's take a look at Article 6, the non-discrimination article under the CCPA. Bottom line, key takeaway, as I'm sure you could have guessed, is that the CCPA prohibits discrimination. A business cannot discriminate against a consumer because the consumer exercises CCPA right. Article 6 states that a business discriminates against a consumer if the business treats a consumer differently because he or she exercises CCPA right. An example of a discriminatory practice is if a business offers financial incentives or a special price to a consumer purely based on that consumer not exercising a CCPA right. That will be discriminatory towards the consumers that do exercise those CCPA rights.
Thanks, Ephraim. So I'm taking you through the 6 articles. Now we wanted to just give you some takeaways before we let you get back to your days. Right. And trying to forget that this ever happened, these regulations, probably. Some of you may be shaking your head. So anyway, so what are our takeaways here? And I think maybe I'll do the first 3, but Bob and Ephraim can jump in as necessary. Then I'll turn it over to Bob for 4 and 5. And some of these things we've mentioned already as we've gone through, but if you haven't gotten the takeaway already, there's a whole layer of complexity here that these regs have added, right? I mean, period. I kept on saying during my remarks, you won't find this in the CCPA. Good luck, those types of things. There's a layer of complexity that's in these regs here. And one, number 2, and apropos of this, we'll mention this before. These privacy policies that Bob talked about during his remarks, these are more than ever, these are legal documents. And, there's this concept of doing annual reviews and updating your privacy policy documents, but these are things that have consequences now in the disclosures that you're making. And again, we talked about this in my remarks. You're going to have policies and procedures. We talked about it for handling requests, for documenting these types of things. It's specifically envisioned in the regulations. But I'll turn it over to you for 4 and 5 then.
Yeah, and just kind of re-emphasizing some of the things that we brought up earlier in the notice, that you're going to be in violation of the CCPA if you collect and use personal information of California residents if you do not provide the proper notice at collection, and if you don't provide an opt-out mechanism for the sale of personal information, then you have to treat everyone as being opted out, which can put some wrenches in the way that some of your online marketing and everything else works. So now I'll hand it back to David. I think he'll close it out.
Yeah, so 2 things we just wanted to flag at the end. You've heard us talk about this if you've been on our programs before. We got something we feel pretty strongly about, our data inventory tool. For those of you who are contemplating how are we going to take all this information in and get these policies and procedures done, we've got a pretty slick tool that we do. It's an online platform for clients that is used to essentially send out online questionnaires to all your relevant stakeholders to gather exactly this type of information, right, that is being required to be provided, and to generate, to help us be able to capture and generate these notices, and draft these notices, I should say. We offer that as a reasonable fixed fee to our clients, and it's really a way for us to minimize the cost to our clients and streamline the compliance period. The thing that I'll leave you with then, and I always leave you with this on our webinars, we've got a blog, and this is what I always call the shameless plug section of our webinars. We've got a blog If you're not on it, you should be. Shame on you. You should be tracking us. You should be listening to us. We talk about these things on a regular basis, how we keep our clients updated as to what's going on in this area. It's not something that we push out content on random stuff. We really try to make sure we're writing on things of significance. And it's a good way, I think, to keep up to date, especially if you're saying, how do I keep up to date on all the changes on these things? This is the way to do it. Subscribe to the blog. And we always put key points at the top of the blog posts that will hopefully give you in 5 seconds whether or not you need to actually read the entire blog post. With that, we are at an hour and 15. We're going to close it down. There's obviously questions, and like I said, we'll respond to your questions separately by email. On behalf of myself, Bob, and Ephraim, I'd like to thank you all for attending here today. We'll be in touch soon. The next thing we'll probably talk about is the final regulations. And I know we've got another webinar if you're interested in another week. We've got one on the New York data security changes to the New York Shield Act. Eric DeLay is going to be giving along with Ephraim as well. So if you're interested in what's going on in New York, please take a look at our webpage or shoot us an email and we'll get you that information. Listen, everybody, thanks again for attending today. We really do appreciate it, and we'll look forward to speaking with you all soon. Thanks.